They continue to see themselves as sovereign states. So it says, levying war against them, or in adhering to their enemies, giving them aid or comfort. And why this is really important is because in the United States, treason was limited to actions. You had to do something. In England, you could have treasonous thoughts. And if your thoughts were deemed unacceptable, you could be tried for treason based upon what you thought. Liberty of conscience was extremely critical to our founders. You had the freedom to think what you wanted as long as your actions were not harmful to the United States of America. And why I think this is very, very critical is because we have two things that our nation faces right now. And that is this concept of a hate crime. A hate crime increases the penalty placed upon you because it attempts to determine what you were thinking when you committed that crime. What was your motivation? Not just what you did, but why you did it. And I believe constitutionally that is not an acceptable standard. The Constitution says you are to be judged based upon actions, not upon thought. I think to a maybe a less important degree, but still somewhat, is this concept of political correctness. We're all supposed to think in the same manner. There are certain things that you don't think, you don't say. And this is not, in my mind, in keeping with the spirit of what our founders said. Now, in the case of treason, the Constitution says that the evidence needed, there must be at least 2 witnesses, or if the individual makes a confession in open court. Deuteronomy 17:6 has the same biblical principle in the life of the nation of Israel. Congress, the Constitution says that Congress can fix the penalty for treason by law, but the Constitution of the United States says it may not include what is called the corruption of blood. And what that simply means is an individual who is convicted of treason stands alone. His family, his father, his children, his brothers, they cannot have their lives taken. They cannot have their property confiscated. That treason is like any other crime. Only the individual that commits the treason is responsible under the law. It is not the responsibility of the entire family to suffer, as often did happen under the English system. We've probably got a little bit of time to go on, so I know, and I appreciate that you're being very attentive, and like I told you, there's not a whole lot of ways to make this fun, so we just got to keep on slugging through. But we'll go on to Article 4 this evening, which addresses how the states are to relate to each other. And in Section 1 of Article 4, the Constitution says that each state must recognize as valid and give judicial enforcement to the legal enactments of another state. So that means if I have a valid driver's license, I can drive into Kentucky and into Tennessee and through Georgia and go to Florida and go to Disneyland with my Ohio license. If I am married in Ohio and Doug's in the car with me when we're driving through Kentucky and through Tennessee and through Georgia down to Disney, we're still married. Because all of those states, yes, Samantha pointed to Greg and said, don't forget that. So anyway, marriages. If a will is probated in one state. When my mother died and her will was probated in Indiana and that inheritance then came to me, Ohio had to respect that. Now that's the good side of it, the stable side of it. The problem that we're facing right now is this. In the case of same-sex marriage, what's going to happen if Hawaii or another state decides to perform those same-sex marriages? It's traditionally been that one state would accept and respect the marriages of another state. Now, by statutory law, there is the opportunity for a state to declare that something is against its public policy, and that has been the stand that has been able to be used so far against one state not accepting same-sex marriage. But I don't know, like I said, I'm not a constitutional scholar, I don't know how much longer that argument may be accepted. And that's why some of these states, when they have the referendums and so forth, it has a national import, not just for the people in that state, but for the tradition of government that we have always have accepted. In Section 2 of Article 4, it says that the states may not limit rights or privileges to their state residents only. So if Michigan has a hunting and fishing license, I can drive up to Michigan, and if I want to pay the duty, I can fish and hunt legally in Michigan. Now, by statutory law, they can require out-of-state fees to be higher, like in state universities. If I want to send my child to the University of Oklahoma, they can charge me more because I don't pay taxes in that state. But Oklahoma can't someday get up and say, hey, we're not taking any people from Ohio. So states have to, they cannot limit the rights or privileges, and then the states must extradite those who are wanted to stand crime, to stand trial for a crime. There are a few exceptions. If you go on a killing spree and you've killed people in 3 or 4 states, the state that grabs you first can hold you there and can try you, can make you suffer the penalty of that crime before they hand you over to someone else, to another state. They can require justice be done in their own state before they extradite an individual. A governor may also refuse to extradite if they feel that the person is likely not to receive fair and humane treatment if they're handed over to the receiving state. And we hear about this from time to time now because of the high rate of execution in Texas. There are a number of states who will not extradite serious criminals to Texas knowing that they might face the death penalty. But the governors of each state are given that authority. Now, the Constitution does address the concept here, like we said, hanging over us all the time was the institution of slavery. And at this point, the Constitution does say that a slave does not become free by moving to a free state. He must or she must be returned to his master upon request. That is why on the Underground Railroad, the eventual destination was Canada. There are some that went to northern states, but generally they needed to get out of the country. The goal was for each state to respect the policies of the other states. The process by which states could be admitted to the Union was laid out constitutionally. It was said that no state may be formed entirely within the borders of another state without the consent of the state legislature, or no state can be formed from territory belonging to another state without the state legislature's consent. Now that was one tribe that was set aside, and that was during the Civil War. West Virginia, that territory which is now West Virginia, was highly anti-slavery. And when Virginia decided to go with the Confederacy, that group of people up there actually broke off and created the state of West Virginia. Now, constitutionally, that probably was not allowed. But their argument at the time was, well, Virginia says it left the Union, it's no longer a state, so it doesn't have to give its permission, and as long as the Congress oversees West Virginia becoming a state, then we are within the law. There have been some occasional efforts, not very, met with very little success, to absorb West Virginia back into Virginia since that time, but I think the deed is done, and it's probably not going to happen. Congress makes the rules for admitting new states. This is something to watch because every 3 or 4 or 5 years, somebody gets the idea, hey, maybe Washington, D.C. ought to be a state. Or Puerto Rico, they want to be a state. You know, there are certain people within it. So if we were ever to see any of these territories become serious about statehood, what will happen is the Congress must pass what's called an Enabling Act. And that will authorize that territory to hold a constitutional convention. It will specify the provisions that must be in their state constitution. And then that territory can hold the convention, adopt their constitution, send it to Congress for approval. Congress has the authority to govern territories and other federal properties, and they usually will let what's called a territorial government be established that exercises supervisory control. You have a mayor of Washington, D.C. They have a certain measure of local control. Section 4 then says that the United States must guarantee, or that there must be a guarantee, that each state will have a Republican, that's little r, Republican government. Before a state is admitted to the Union, Congress has the responsibility to make sure it has a Republican government, meaning that its Constitution provides for the election of representatives, that it has separate branches of government with checks and balances, that it has a measure of limited government, and that the state has a Bill of Rights. Section 4 of Article 4 says, and I find this interesting, it is the responsibility of the United States to protect states against the dual threats of foreign invasion and domestic insurrection. That is the responsibility of the United States. In Article 5, we are given the means by which the Constitution may be changed. You know, we hear this argument right now. Well, the Constitution is a living, and it's a breathing, it's a growing, it is an organic document. It needs to be allowed to change and grow. Well, let me ask you this. How would you like it if your bank took that same approach to your mortgage? Well, I know that we have a contract for 3% interest, but this document is living and growing and breathing, and we're having some trouble with Wall Street bailouts, so this month your interest rate is going to be 25%, or we're going to call the loan. That's the same concept with which some people approach the Constitution.